What do we want?
Social justice. Social justice.
Like we always do about this time.
Social justice. Social justice.
This is a Social Justice Hour brought to you by the Law Office of Ernest B. Fenton. I am Attorney Ernest B. Fenton, your stop foreclosure attorney at the Law Office of Ernest B. Fenton, where we are more than just a law firm. We are consumer advocates, and what that means is that we are primarily interested in serving and protecting the rights of individuals and small businesses, no matter the opposition.
Today's hot topic of the day: the Michael Jackson estate fiasco. What is going on with the estate of Michael Jackson? Why is Randy and Tito and Jermaine acting up? Why has Miss Jackson taken refuge at Reeby's house? And where's LaToya? I haven't heard a peep from LaToya. And does anybody know where Joe is at? Now, when Joe get involved, we might have some problems. And then what's most important in this discussion is you and your family. What I want to make certain of is that you take care of your family, that you handle your business right now. So the theme of the show, your business, your primary business, is handling your business. I'm going to keep it real simple. Do you think the children are tripping? Do you think that Michael Jackson should have left some money for Randy and Tito and Jermaine? Do you think they actually have a claim to contest his estate and his will? Are you even aware of what's in his will? Is it his will that they're really contesting? Let's go to Jane. Jane from the South Suburbs. Welcome to the Social Justice Hour.
What is the role of an executor?
Gotcha.
It appears as though the executor, in this case, like the Jackson case, has more power than the family, than the mother even.
Gotcha.
Can that be overturned legally if the family decides to fight it?
A pour-over will and a living trust is what Michael Jackson had. And he also had some other trusts, I do believe. What is a pour-over will? First off, let's establish that Michael Jackson did not allocate or dispense any of his assets via his will. You say, that sounds strange. That's the entire point or purpose of a will. No, Michael Jackson had nothing in his will. What Michael Jackson had is called a pour-over will. What's a pour-over will? A pour-over will is an instrument that says, whatever assets I may have, I'd like you to transfer those assets to my living trust. Michael Jackson's estate is enveloped in his living trust. You have a trust, you name trustees. You have a will, you name an executor. The purpose and point of an executor and a trustee are pretty much the same. Their job is to carry out the desires of the decedent. Now, what Michael Jackson did was he took all of his assets and he placed them into a living trust, right? And then what he said, pursuant to his living trust, is 20% of my assets shall go to charity. Let's get this straight, people. Michael Jackson gave 20% of his estate to charity. He specifically said that the charity should relate to the welfare and the well-being of children. He named his mother and he named his two executors to determine which charities would receive the 20% of his estate. And he gave 20% of his estate away off the top, before taxes, before fees. In fact, most of his money went to charity. Once you take out estate planning taxes or death taxes from an estate worth more than $3 million, so if your estate is not worth more than $3 million, don't panic. There are no estate taxes. Michael Jackson's estate was worth more than $3 million. There are estate taxes. Once they hit him with the estate taxes, charity, in fact, received most of his money or will receive most of his money. But 50% of his remaining estate went to his 3 children, and the other 50% of his remaining estate after charity, after taxes, after Uncle Sam, after attorneys, went to his mother. Aha! The plot thickens! Now you get why everybody is looking for Catherine. But hold on. In a living trust, not pursuant to his will, Now, he also named Catherine, his mother, as the guardian of the children. He named non-family members as the executor of his estate. So these non-family members, they make the decisions with respect to how the funds will be distributed during Catherine's lifetime, because Catherine is not going to receive one fat check for 50% of the remainder of his estate after taxes, after charity. He said, pursuant to his living trust, that Catherine should receive so much as of the money as is necessary for her well-being, care, and comfort. So they're not going to write Catherine a check for $200 million. And guess what? Catherine can't decide how much money she needs. The executors get to decide. That's the dissension. The executors, I think it's, what are their names? Let's go to the names. Where's the name?
John Branca.
Right down. John Branca one is an attorney and one is an accountant. They were business advisors for Michael Jackson. Now, they have been allocating approximately $75,000 a month for the care, comfort, and well-being of Michael Jackson's 3 children. Guess who gets the check each month, that $75,000 check? Catherine gets the check, because Catherine is the guardian of the children. Michael Jackson named his mother as the guardian of the children. So she gets the check because they're minors. So she also gets her own check for her care, her comfort. So let's just presume, and I'm making this number up, I have no idea what this number is. Let's presume that Catherine's getting another $75,000 check. So Catherine's getting $150,000 a month from the estate of Michael Jackson. Guess how much the rest of the siblings are receiving each month from Michael Jackson? Nothing, Jane. Michael Jackson didn't leave his family a red cent other than his children and his mother. Michael Jackson created his estate plan. He knew exactly what he was doing. People will say, oh, maybe he was sick, maybe he wasn't in his sound mind. Michael Jackson created this living trust and his pour-over will, I believe, in 2006. Oh, maybe he was sick, maybe he was on the drugs. No. What the family is contesting, or what they are claiming to be in contention with, is the fact that these 2 gentlemen, this accountant and this lawyer, are the executors of his estate. They're saying that they're not doing a good job. Let me just say this. When Michael Jackson passed, it was reported that he was $500,000 in debt. What, a year or 2 years after his passing, his net worth is $1 billion. If they're doing a bad job, I'm just saying, I don't know. I don't, would you want Randy handling the estate? You want to name Randy as the executor? How about Jermaine? Because it seems like they're broke. Clearly, Michael Jackson was a very intelligent man. He carefully thought about who he wanted to be the executor of his estate, who would do the best job to make certain that they would capitalize on his goodwill and his assets, such that his children would be taken care of and his children's children would be taken care of, and that money would be there for his charity and for his mother. You don't need $1 billion estate to have estate planning be as significant for you and your family as it is for the Jackson family. I said a simple issue like, who's going to provide the care for your children in the event that something happens to you? Estate planning will determine that for you, or otherwise the courts will. So if you have children, we need to think about guardianship. If you have any assets today, then we need to think about a living trust, or we need to think about a will. And why did Michael Jackson place his assets into a living trust as opposed to a will? Because a will can be contested. If Michael Jackson would have placed all of his assets into a will, they would be in court right now clamoring over every aspect of his estate. He was smart enough to place it in a trust. A trust is not subject to probate. If I leave you $5 pursuant to my trust, the day I pass, you can walk to the bank and go get that $5 with the proper documentation. If I leave you $5 pursuant to a will, I pass, you may be in court for the next 2 years trying to get that $5. People, this is not about Michael Jackson. Listen, people, get your estate plan together. I mean, imagine if Michael Jackson did not have his estate together. his estate would be tied up for 5 years. And you know what? Let's get this out of this conversation. Exactly what he desired is taking place. His children will be taken care of for the rest of their lives. Let's also get this, a spendthrift trust. He's not going to give his children a fat paycheck when they turn 21. Part of his trust, a provision of his trust, is called a spendthrift trust, which means that his children will only receive enough money for their maintenance and care and well-being until they're 21. The executors make the decision as to what amount is necessary. Right now, they've been dispersing approximately $75,000 a month to Catherine, who is the guardian of his children. Guardianship. So think about that. I know you're in great health. I know you know that nothing's going to happen to you. You're going to live to 100 years old. I get that. But you still need to appoint a guardian. You need to put some paperwork in play because you don't even know where your baby daddy's. Oh my God, did I just say that? What if, Mom, you had a child with a man who's no longer in the picture? You don't know where this man is at. You pass and then he shows up because you left your child some money. Guess what? He has a very strong case to be guardian. You know why? No, not even guardian. He's that child's father. He can just go and snatch his child and get the money. Now, would there be a court battle? Yes. Yes, there would be. But why go through all of that? Spendthrift trust. At the age of 21, all three of his children will receive a third of the corpus of the trust. Corpus is the body of the trust. So if there's a $500 million in the trust, you split it up 3 ways. If there's $500 million in the trust when the first child reaches the age of 21, if Catherine is still alive, $250 million of those dollars will be Catherine, so that child would not have access to those funds. 1/3 of the $250 million will be allocated to that child who reached the age of 21, and 1/3 of that 1/3 that child will be able to receive at the age of 21. So at the age of 21, based upon this example, and if I can do the math in my head, we're talking about maybe $10 million will be allocated to that child as an example. When they reach the age, I believe, of 30, I'm guessing on this, it's about 30. Then they're able to receive another third of their share of the estate. And then when they reach the age of 40, they're able to take all of the money, all of their share from the estate. When Catherine passes, her share of the estate will go to his children. Catherine is 82. If Catherine passes at 100, the children will get the remainder of her estate. Catherine's only going to get $60,000, $70,000, $80,000 a month. But pursuant to the trust, if Catherine wants to start a business venture, she can ask for additional money. If there's something going on in her life, like her children are down and out, Catherine can go and say, you know what? I need $500,000 because I want to help my children. And guess what? I think the children know that too. But she needs to have a significant reason as to requesting additional funds from the trust. A lot of people think of their estate as being what they have in cash. Get this, audience. Your estate is everything that you own. The watch on your wrist, the shoes that you have, art, car, and all that stuff has value. Your home. So people say, I don't have anything because they say they don't have any money. Let me tell you, a lot of millionaires don't have $1 million. They can't go to the bank and withdraw $1 million. They're millionaires on paper. People make the mistake of not funding their trust. Let me give you an example. If you have a bank account, you can go to Chase, wherever you go, Bank of America, blah, 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 worst people in the world. Did I just say Bank of America and worst people in the world? Yes, I did. So, whatever bank Seaway, you go to Seaway, you open up a bank account, right? Now you just have a bank account. Until you put money into the account, the bank account is worthless. It's the same thing with the living trust. You can create a living trust, but if you don't transfer any assets into the trust is worthless. So if you have an asset like a car that you like to be in the living trust, you need to change the title into the name of the living trust. You need to change your bank account into the name of the living trust. Or you need to name the living trust as the beneficiary of your bank account. Now, let me tell you what you can do with respect to the payment. You can simply execute a bill of sale or a title, and you can transfer it over to whomever you desire, and it's gone. The trust only relates to whatever is in the trust. You can take anything out of the trust that you desire as long as the trust is a revocable living trust. 708-991-7268. Call me for your estate planning needs. Land trust, living trust, pour over wills, Powers of attorney too, people. You need a power of attorney. Good Lord, you're killing me.
I know it's difficult to appreciate the value of an estate plan until you have to use it. Hell, I know it's also uncomfortable to think about our parents being sick and not being able to make healthcare decisions on their own or make other day-to-day decisions on their own. But it does happen. So why make a difficult moment more complicated? Make the first step, create an estate plan.
Thank you, Ernest B. Fenton. A peace of mind means everything.